So also warm welcome to everybody who's dialed in now. We're still waiting for a couple of minutes. We already have a lot of attendees, and I see that people are dialing in now a lot. So let's just wait a couple of minutes more. Yeah, and maybe to entertain you a bit while you're waiting, I can show you a video that we generated recently. So we here at CoAuth and Florac, and I guess all of you that are watching today are really passionate about IP, but we realize that public opinion sometimes isn't so passionate about IP. So what we did is we tried to put into a video, what IP means to us, to also reach what one might call the YouTube generation of today. And let me just show you the result.
Our world is full of small and big miracles, full of fascination and inspiration. While some may see a dolphin in it, others see ergonomics and efficiency. For some, this is just an insect. For others, a revolution in the development of cameras and monitors. And some may only see simple leaves here, while others see the protection from dirt and water. Inventions are a part of our nature. But even if inspiration is omnipresent, in the end it requires a person to recognize it, adapt it, and develop it further. But what would our world be if no one were interested in inventions anymore? Because research and development simply no longer pay off. An invention goes through many process steps until it is ready for series production. A problem has to be identified and a solution found. Research and testing are required. Product samples and prototypes have to be made. That costs time and money, sometimes even a lot of time and money. It would be all the more tragic if people then came along and took the idea away to use it for themselves, where all the energy, all the effort, and all the preliminary work then become more or less worthless in an instant. And what would it ultimately mean for society if inventions no longer paid off? Society would stand still, and things would not progress. That underlines how important it is to secure the development of ideas, because that is the only way to create something new. And that is exactly what German innovation protection ensures. Something that for us in Germany as a leading export nation is of particular importance. It provides security for the developers, for us, and for our future.
Yes, so welcome everybody to our webinar today. The topic, is co-ownership of IP. It's the first part of a three-part webinar series that we'll have, and we are extremely pleased to see so many of you having dialed in. And the next thing I want to do is introduce today's speaker. We're very happy to have Eric Schäfer here. Eric is a fellow partner of mine here at CoAuth and Florac. He's an attorney at law. He's a very experienced litigator and arbitrator, but in our firm, he's especially the specialist for all contractual aspects of IP, so drafting contracts and advising on contracts. After his studies at the University of Freiburg and several stays abroad, he actually started his career at the Court of Arbitration at the ICC in Paris, then spent several years as an in-house counsel in an industry patent department, went into private practice, and then joined CoAuth and Florac in 1997. And as I said, he has a lot of experience both from the arbitration side, so what can go wrong also when contracts are not drafted correctly, or when there's actually no contract at all in place, and this becomes very difficult in co-ownership situations, as you will hear from him Today, Eric will focus in particular on the legal basis for co-ownership, with a focus on the legal situation in Germany, which illustrates to you what can go wrong if you do not regulate details by way of a contract or agreement. And then, of course, Eric will also provide some advice and tips of what to keep in mind when drafting co-ownership agreements. And with that, Eric, I would like to hand over to you, and I'm looking forward to your presentation, and of course also to the questions of the audience. So please make use of the Q&A tool, and we look forward to receiving your questions.
Thank you, Natalie. Welcome to everybody. Unfortunately, I cannot see you. You can see me. This is for me quite a new experience. If you see my eyes moving strangely, this is because I have no television speaker training, and the camera is directly in front of me, but the screens where I can follow my presentation are slightly above. So you will see eye movements that look a bit weird, but are explainable by the situation of our setting in the room where I am. If you want to put a question while I'm speaking, please do so. Natalie will interrupt me, and I will try to deal with this question right away. Otherwise, we'll have enough time, hopefully, to deal with questions or comments even after the presentation is finished. The presentation is starting, as always, with an introduction. We will then look into the German legal concepts concerning co-ownership. We will have a look at the international scene and how that is interlinked when you have co-ownership situations. And then we will deal with some important, probably the most important specific issues related to co-ownership as exemplified by court cases. And the whole thing will end with some learnings from what has been said before in the conclusions. So let's move to the introduction. L'enfer, c'est les autres. This is a play by it's a part of a play by Jean-Paul Sartre, and explains a bit the situation in which many parties find themselves when they cannot agree and are co-owners of intellectual property. It's a bit provocative since in most cases, in my experiences, the co-owners manage difficult situations where there are conflicts of interest rather well. But the few cases that remain and the few cases that lead to reported court law are normally very unfortunate situations for the parties on all sides because they cannot fully exploit their IP. The special situation we find in relation to copyright and also inventions is that they originate in the inventor and are then passed on by operation of the law or by a labor contract or other contracts to another owner. But you can never avoid that if you have several inventors, the rights to the invention will first vest in these inventors, and they are co-owners in the rights to the invention. Of course, IP has one single purpose. It's a monopoly, and it is secured in order to generate profits. And this requires, on one side, initial investments, then investments over time. And on the other side, there is an expectation that becomes more seizable over time also, that makes the owners decide to invest. All this requires the owners to administer the IP and to cooperate. However, co-owners often pursue different commercial goals and have divergent interests. And these interests are not static, they evolve over time. And this can impact their respective view as to how their joint intellectual property should best be exploited and how much should be invested. This is a source of conflict that usually delays or hinders decisions and wastes resources of business opportunities of at least one of the co-owners from its perspective. Of course, unless there's an explicit agreement in place that provides for a viable legal and commercial solution of the conflict. In the absence of such an agreement, the co-owners are thrown back to what the letter of the applicable law provides. This presentation will use the German example to show what this implies for a co-owner. This is important. This presentation shows what happens if there is no agreement in place. And this is something you all need to know in order to manage the risks that come with co-ownership. And as soon as you know the risks, you normally find also the solutions to avoiding these risks or to mitigating these risks. This topic is a bit arcane. It's very technical. Property law is a very dry and technical issue, but due to the many cases where you have co-ownership of inventions and co-inventors, it has quite some practical importance. We now right away jump to the statutory legal concepts of co-ownership. Under German law, co-ownership is governed by the German Civil Code, BGB, Bürgerliches Gesetzbuch, for all kinds of private co-ownership. There are no special provisions for IP except for copyrighted works, especially literature, which we will not deal with because this is also a very complex issue and probably less interesting to all of you. The German Civil Code was put into force in 1900, and that was a different world. And you will now see that that has a certain impact. We have two concepts for joint ownership. We have the joint part ownership, it's called Bruchteilsgemeinschaft, and we have the undivided joint ownership, Gesamthandseigentum, which comes with a sort of civil partnership that is a contract of association. So if you listen to me, you will probably see that the joint part ownership is the one that is preponderant in reality, and also the one that creates problems that have been decided by the German courts in a handful or two handfuls of decisions. There are not too many decisions. Joint part ownership, Bruchteilsgemeinschaft. This ownership concept applies as default to joint ownerships unless the owners pursue a common goal on a contractual basis that qualifies as undivided joint ownership. Since the BGB was drafted having tangible property, cultivable land in mind, its rules raise quite some issues when applied to ubiquitous intangible assets such as IP. Joint part ownership is characterized by the following features. Each co-owner owns its own share in the property, which may equate to its contribution to the invention, but will, in case of doubt or disagreement, be identical to the percentage of the other co-owners. Each co-owner may freely assign its share, and the assignee follows into all resolutions which may have been agreed for joint administration. Full ownership may only be assigned by all part owners. Each joint part owner may independently use the joint IP to the extent that it does not hamper the right of the others to use their share in the joint property. Each joint part owner has a right to the fruits, exploitation benefits, corresponding to its share in the joint IP ownership. Each joint part owner must participate in the costs of administering and maintaining the joint IP in proportions corresponding to its ownership share. The joint partly owned IP may be administered in an orderly manner and used in accordance with the majority resolution of the joint part owners. Each joint part owner may request the other owners to participate in the necessary orderly administration and use in a discretionary, equitable manner that is in the common interest. That is a standard. We will revisit this rule later on, because the term equitable manner plays a major role in what the court have decided in regard to certain questions. So paragraph 7452 BGB is a crucial rule within the rules governing joint party owned IP in Germany. Each part owner may undertake the steps required for maintaining the joint IP without the other's consent. This is important. And may require them, this is also important, to give their consent in advance. This comprises the right to sue infringers and thereby impinge the monopoly resulting from the joint IP. This means that a joint owner in Germany may sue alone and request a cease and desist order from the court. However, the thing is a bit more complicated when we talk about damages and other kinds of compensation, because each of the joint part owners has, of course, only a fraction of the rights to these damages, and that must be reflected by the procedural arrangement. But the claims to cease and desist may be levied by each joint part owner alone. However, a substantial modification of the joint IP may not be required or decided, nor may the usage right of a joint part owner be restricted that corresponds to its share in the user's rights. This is a rule that creates certain problems for the administration, because this rule is made for land and tangible things where you have one object and that exists from the beginning to the end. And IP, as we all know, is something dynamic. We have the invention becomes a first filing, the first filing becomes foreign filings, and that means that the property the owners jointly own evolves and changes in size automatically. And for such a situation, these rules produce some questions which can be solved, and which fortunately, apparently are solved by the co-owners in general, because I have not found any reported case that would be very interesting for you. The only cases we have found relate to the payment and contribution of maintenance fees and prosecution fees. If a joint part owner relinquishes its property share in the joint IP, for example, a national part of a patent family, its rights will proportionally accrue to the remaining co-owners. Unless excluded by agreement, each part owner may request the dissolution of the part ownership at any time. The dissolution is either effected by way of division of the joint IP according to the shares, difficult, or if impracticable, by public auction, if also impracticable or unequitable, by way of auction among the owners. And this, of course, is a horror scenario. There are no reported cases, but if you have an interesting family of patents and you are fully exploited and one of the co-owners requests you to dissolve the co-ownership, you may be confronted with very unpleasant questions, and you might only be able to resolve this issue by paying this co-owner who creates the problems an amount of money you would not have paid under other circumstances. We now come to the second kind of joint ownership, which is the undivided joint ownership. Undivided joint ownership requires that the part owners of the invention pursue a joint economical goal, wherefore they have explicitly, and this is the problem, tacitly formed a partnership under the BGB. Under the BGB, under German case law, it's possible to form tacitly by simply acting as if we were a partnership. And this is a very tricky factual issue. When do you start to act as a partnership? A partnership, and the agreement then of this partnership then obliges the part owners to make their due contributions, which in our case would be the transfer, the assignment of the part-owned IP to the partnership. If the obligations of the partners are not explicitly agreed, the BGB fills the gap. In most instances where the parties enter into explicit partnership or a partnership where it's not said that it's a partnership, but it works somehow like a partnership, they will have elaborate contractual rules. This is the reason for which this normally doesn't play an important role in disputes, at least not of the kind we are looking at here today. But still, if that all has not happened, and exceptionally a court would determine that the parties are not in a part ownership, but in a joint ownership because they pursue a common goal and have formed tacitly a partnership, the legal situation is rather different to one under the part ownership. Firstly, the part ownership holds all rights and title in regard to the IP, and also all proceeds thereof. Only the partnership and not a partner may grant licenses. The share in the partnership is as such not assignable. All partners jointly represent and manage the partnership unless agreed otherwise. If one or more partners are designated by the partners as managing partners, or the others are excluded from management, managing partners may legally represent the partnership towards the outside, to third parties. All partners participate in the proceeds of the IP exploitation according to their share, unless otherwise agreed, and losses must be compensated when the partnership is dissolved. In reality, the claim to participate in the proceeds is only due when, at the end, when the partnership is dissolved. Any prior distribution of proceeds would need a resolution of the partners. Unless otherwise agreed, the partnership ends if a partner dies or insolvency proceedings are opened in its regard, or if the common goal is achieved, which would be, for example, if all patents in the family that are jointly owned have expired, or if the goal is unachievable, or if a partner terminates the partnership agreement for cause. This may not be effected, this termination may not be effected at an inappropriate time. What that means depends on the individual case. I cannot give you any specific guidance in this regard in the context of our today's presentation. If a partner leaves the partnership, its share in the partnership accrues to the remaining partners proportionally. A partner may not claim the division of the joint IP upon leaving the partnership or its dissolution. The described liquidation procedure must be implemented. This means that independent direct IP exploitation by a partner is not viable unless agreed with the other partners. Since IP is a monopoly to exploit, EU antitrust rules must be taken into account in regard to which restrictions on any partner are listed when the partners agree on exploitation. This is the situation for all jointly owned IP that is in force in Germany.
Eric, can I just interrupt you briefly, because we actually have the first questions here. So Jörg from the audience asks the following question, and it deals with priority applications, which we will also deal with specifically in the two next parts of this webinar, but maybe you can already comment on this, Eric. The situation is the following: you have jointly filed priority applications, so first filing filed by two co-owners. However, one of the co-owners is not interested in a foreign filing, so in a second filing. Will the rights automatically transfer to the other owner? Yeah, and is there a duty to cooperate? So I think you will touch on that, but what happens if yeah, one of the co-owners loses interest in the foreign filings?
If you have part ownership, Bruchteilsgemeinschaft.
Yes, I think, for example, I mean, probably
the situation will be very different, because if you are in a joint owner situation with a partnership, they have mutually duties to be loyal to the partnership. They must do everything that is required in order to make the partnership a viable success. In short, so due to this contractual situation under the partners, the duties to participate are much more tangible than they would be for part ownership, where the people have no contractual relation under the law of obligations, but just rules relating to the joint administration and use of the IP. At least to me, it is clear that the right to claim priority is part of the rights to the invention. And therefore, what I have explained would also be applicable to the priority right. Now, the big difficulty is, even if you have a claim that because, you know, if the issue is, if they do not abandon explicitly their property and just sit idle, they are still owners. So you must have a situation where they abandon their right. You have seen that if one part owner abandons its right, the rights accrue to the other owners. But here, that party simply drags its feet. There is not much you can do. The only thing you can rely on in this kind of situation is to say this is part of the joint administration, and you have a duty to participate in this decision because this is part of the joint administration that serves to maintain the value of the inventions as they have been filed.
Yeah.
But in the worst case, just let me finish. In the worst case, you have to litigate that, and there you fight against time, because any court proceedings against that party, perhaps you could think about, exceptionally in Germany, very exceptionally, because you would get satisfaction, you could think about an interlocutory injunction. But normally, these periods of time you have to do all the necessary with the PTOs, the patent offices, are shorter than the time you will need to litigate and get a favorable decision from a court. And then the whole thing is converted into a damage claim, which you may have, but that might not really be what you want. You do not want to have a damage claim, you want to have the IP in that country. The situation is a bit unfortunate, and therefore I have this title to my introduction, L'enfer, c'est les autres.
Yeah, and I think one also has to distinguish between the rights that you have under the law and, on the other hand, the formalistic approach that, for example, the European Patent Office takes. And exactly this will be the subject of Professor Hedeke's talk next week. So exactly this situation that you have pointed to. Yeah, but so that's why, please continue, Eric, with the next part of your presentation.
Yeah, but it's an important point we always need to bear in mind when we deal with these matters. The patent offices worldwide have their own deadlines and their own agendas, and they don't wait for you when you have this kind of discussion or dispute with one of your co-owners. And normally you will need a signature, you will need something, perhaps even notarized documents and so on. And if they don't participate, it's very difficult to resolve this issue in time. And then you end up perhaps with damage claims, but this is not really what you wanted. You wanted the IP in that country. Okay, let's continue with another aspect, which is the multiplicity of applicable ownership concepts. And that makes everything still a bit more complex. Many inventions are made in joint efforts by parties who reside in different countries. In spite of treaties such as the EPC or the PCT, inventions evolve from being secret know-how into national patents or utility models, or national parts of EP patent, which all are subject to the law where they are in force. And this means that law also governs in each single case co-ownership. Because this is not in itself an obligation. It's not of contractual nature. It's really directly related to the statute of the property that is concerned. And you have no possibility to opt out of that because it's happening by operation of the law. And this implies that the legal rules governing co-ownership as such are those of all those countries where the respective IP right is in force. And these legal rules may be different from the ones I have just described. But I guess they will not be much simpler, and they might also have the same background, that they are not really drafted for IP situations and the specific need of joint owners of IP. However, since undivided joint ownership depends on the existence of a, sometimes, as we have seen, partnership agreement, a different regime applies to that aspect. Unless the partners, which they will normally do if they come from different countries, have chosen the applicable law, the uncodified issue of the applicable, at least it's uncodified here in Germany, applicable law may be decided on the basis where the partnership was formed or where it has its seat. There's a problem if it changes the seat, and that is a discussion about partnership lawyers. We need not to go deep into that, but the advantage of a partnership, it has other inconvenience, which we will have seen and which we'll see more clearly later on. But a partnership at least would be advantageous insofar as it would be a sort of bracket that holds together the IP, because the original IP is with the partnership and not with each partner, and therefore the partnership could be the owner also in all other countries. Of course, this would still not solve the problem if a partner would need to make declarations or provide signatures and refuses to do so. All in all, the multiplicity of laws and these rules makes things more complex and more difficult. And this means for a company that has a co-ownership just starting, the invention is made and no agreement, there are many uncertainties, and these uncertainties translate into risk, and this risk must be somehow dealt with. As an intermediate result, we can conclude the following. Whenever different parties jointly engage in innovation activities that could result in IP, they should contractually, explicitly agree on how to prosecute, how to maintain, how to enforce, and most importantly, how to exploit the IP. At a time when one mainly sees the prospects but not the risks, which means initially when you have your successful R&D cooperation, for example, or you're just about to start it, this may easily appear to be a futile exercise for hypothetical events. but compared to what a dispute entails, analyzing the respective business models of the prospective part owners and their implications for the potential future conflict with a view of finding a common ground is clearly the less onerous exercise. I would really like to emphasize this. At the beginning of a cooperation, it's perhaps great to look at the prospect of a new product which one develops together. But one should look at the business models, try to see whether there are future potentials for conflict, talk about it. This is sometimes even more important than having a perfect agreement, but talk about it with the other side, find common ground and a viable solution that will avoid that all co-owners get stuck with a dispute for too much time and need to waste their resources in resolving that dispute. Therefore, for any party, it also makes sense not only to define its own goals, but to lean back for a moment in the beginning and think about the goals of the other side in the cooperation and what the other side may request if in the future the result is exploited. Unfortunately, parties have very often ideas that for a solution that are problematic from an antitrust law perspective. We cannot deal with this, but whenever we talk here about agreement and how to exploit and how to do certain things, as soon as the market is affected by the implementation of these agreements, you may need to have also look at what is allowed by antitrust law in the places where you are going to exploit. We now come to the specific issues which are easily identified. The first one is the administration of the joint IP. First point is first and subsequent filings. As explained, the German co-ownership laws have a static view of the owned object, whilst IP is dynamic. Notwithstanding, there are hardly any reported German cases. Seemingly, parties tend to solve upcoming issues in advance or when they occur. As always, better say safe than sorry. The part owners need to decide whether to keep the invention secret or to file a first application, which will be published after 18 months. Should such agreement not be reached, the issue arises whether a partner may proceed in the common interest with filing without the others' consent within the scope of the powers provided by the BGB. Furthermore, an agreement regarding the content and scope of the patent claims should ideally be reached. In this regard, the German Federal Court has found that filing only in the name of the acting co-owner is not covered by the right to administer alone. The decision is silent on whether this part owner may always file in the name of all part owners. If you do this, of course, you have other problems because you don't get their signatures and all the rest you need when you pursue in the name of all part owners. And therefore, in that case, the filing partner was held liable to damages and had to assign in part, which means the partner who filed in its own name had to assign the part of the IP that corresponded to the other party to that other party. I have been thinking about whether this situation could be resolved. Even if the German Federal Court is very clear that you cannot only file in your own name alone, one could try to somehow remedy this by, first of all, being transparent about filing. In these cases, the filing partner was not transparent about filing to the other co-owners. And secondly, one could think about a construction of trustee ownership. So he is to the outside the only owner, but he acts as trustee for the other co-owners. Unfortunately, a trustee relation is a contract that requires consent under German law, Treuhand. And all the acting co-owner could do in reality is to inform the others and make them an offer for such trustee agreement, and they are free to accept or not. If they accept, the situation is cured. If they do not accept and that partner files, that might be a different set of facts at which the German courts might look differently if there is full transparency during the whole process for all the joint owners. Well, that might be a solution, but it's not tested in court. Even if one partner does proceed in full control of the filing process, this partner must be mindful not to disclose confidential information of the other party in the descriptive part of the application, especially if this is not part of the invention as such and not as such covered by the patent claims, since this may lead to damage claims and claims to cease and desist under any confidentiality agreement or by operation of the Company Secret Acts, which is the Geschäftsgeheimnisgesetz and which is based on harmonized EU law. This is not directly related to our issue here today, but I have seen in arbitration quite a number of cases where this has happened and has led to bitter disputes. That is, one party files alone for something it believed for one reason or the other, or didn't believe for one reason or the other in its own name, and the others say there was our know-how in the invention, we are co-inventors, or if we are not co-inventors, at least our confidential information was disclosed, which we wanted to keep secret. So that must always be kept in mind. Therefore, also in the beginning, transparency among the co-owners, even if one partner has the leading part in the filing, is important, since the other co-owners should have the first application for review in order to be able to alert the filing partner if they think that there is information that is their secret information and that is not part of the joint invention and that should not be disclosed. This normally helps to avoid disputes, which strangely, I never thought that that would be the case, do happen not so seldomly. Since the drafting of the patent claims concerns the substance of the property, one could argue that this is not covered by the authority to administer alone, because this affects the substance. However, in my view, the application of equitable principles enshrined in paragraph 242 BGB, which is the general principle of good trust and the source of secondary unwritten duties, is an argument against such a solution, if the required professional care is applied, of course. And I would like to add probably also if this is coupled with transparency, so that the affected parties are at any time fully informed. Analogous considerations apply to subsequent foreign filings, but as explained, if there is no partnership agreement around or other kind of contractual agreement, these are subject to other local laws. Second area, maintenance and defense of joint IP. Patent maintenance or defense and opposition or nullity proceedings are part of an orderly administration in the common interest. However, subsequent disputes may arise if the acting part owner tries to recover part of its costs in accordance with 748 BGB and the part owner who was not interested refuses to pay. I have included a decision to first instance Düsseldorf court, where the court rules that the other part owner who remained inactive had to restitute its share to the partner who had paid. Now comes the first big and difficult issue that at least gives rise to many legal discussions and probably also has quite some bearing in practice. This is licenses to third parties. Here, it's in part clear, in part not clear. Without the consent of all part owners or partners, so in the two settings, no part owner or partner may grant a third party an exclusive license to use the joint IP, since this excludes or partially excludes the others. This is the substance of the jointly owned IP and therefore may not be affected. IP commonly owned by a partnership may only be licensed exclusively or on a non-exclusive basis by the partnership, unless agreed otherwise. When a part owner may grant non-exclusive licenses alone within the scope of its users' rights is debated. Whilst important authors argue in favor of this solution, the Düsseldorf Court of Appeal has decided in two cases that granting a license is part of the orderly administration of joint IP, which normally is performed jointly. Of course, the orderly administration also implies the right of one partner to request a decision from the others. But this decision is only justified if, or it may only request a specific decision to consent to licensing if this is equitable and serves the joint interests. According to the OLG, at least either a majority of votes decision authorizing the license grants is required, or the part owner intending to license must have an equitable claim under 745 BGB. This is what I just mentioned. Neither decision, unfortunately, contains guidance as to the circumstances that would warrant such a claim that the others agree, since this was not an issue in the absence of a request for consent. The other spiny topic is participation of the other co-owners in the proceeds of another co-owner. And this is for many a bit unexpected. Therefore, probably something most of you were not so aware of. And this is that participation in the proceeds of the exploitation of joint IP is a normal case in a partnership setting with common ownership unless specifically agreed otherwise.
And Eric, can I just interrupt you shortly? What does this proceeds mean exactly? Can you describe it in lay terms? Would it be revenues generated under the IP?
Okay.
Or?
Okay, you can distinguish two things. You can have license fees. License fees would enter in the field of fruits, which means it's a result from the exploitation. And then you have the free use of the, and that is a problematic part. Each co-owner can freely use its share and keep what this partner earns. But still, this is revenue, and this revenue may be, whether by using the patent itself and many activities, this revenue is in first place revenue of that partner, but it may be improportionately big in comparison with what the other partners can achieve if they would try to exploit the joint IP. And we talk about
means the proceeds means license fees and own revenues that derive from the IP.
This means licenses and all other kinds of revenues. Yeah.
Okay. Thanks, Eric.
And I hope this will become clearer in a moment. I know I run short of time. I will try to accelerate, and perhaps we will skip something in the end.
I think it's fine. Yeah. Please.
Okay, it's fine for you. You tell me when I should accelerate.
Yeah.
Yeah, okay, thank you. In the event of a part ownership, this was unclear for some time because each part owner, as stated, has its right to use its share freely to the extent that it does not adversely impact the usage right of the co-owners. However, each part owner has only a right to the proceeds that corresponds to its share. With a leading decision, the German Federal Court found in 2005 that the fruits rule only relates to the procedure such as licensing fees and so, but not to the procedure achieved through own use, which basically remains free. Only if such use generates proceeds exceeding the equitable degree of own use, other part owners may request under 7452 a decision for an equitable share in such future income. So it's important that this must be requested, and then it works for the future. As long as it has not been requested, it need not be paid. So there's no duty to render account all the time. It only starts really this duty when it's requested, because it's a request under this joint administration rule. In a subsequent decision, the OLG Düsseldorf in 2014 defined the required criteria as follows, and this is important for all of you. For the request of compensation, making a claim for rendering of account is sufficient. Secondly, the claim must be equitable. That means the extent of use by the other part owner must exceed the share of the claiming party and the share in its ownership, and is put in relation to the ownership's shares of the requesting part owner. If the using part owner has only made relatively small use, this may be an argument against the compensation. The reasons for which the claiming part owner does not sufficiently use its own share does not have decisive relevance. If there is such claim, respective shares are determined, and the chosen basis for determining the compensation amount is license analogy, at least according to the OLG Düsseldorf court. There are perhaps other approaches, but that was the approach they determined to be the proper approach. In a subsequent case, the same court clarified that the equitable evaluation implies that all relevant facts be factored in. In that case, the claimant had shied away from certain exploitation risks which had been taken by the respondent. The court held that if one party took such risk and the other shied away in spite of the possibility to use, a compensation claim may be denied. What do we learn from these decisions? We learn from these cases that the law concerning compensation claims is formed by case law, which depends on the circumstances of the individual case, because we confront an equitable claim. And this results in less predictability. So you can not be sure what the outcome will be if you are confronted with such a claim. But you get a certain guidance, and you know in which direction, as the party who is requested to pay, you can develop your arguments. But unfortunately, at least you will have to render account to the other party so that they can quantify their claim. In its decision and further decision, the OLG Düsseldorf confirms, and that is also important for you, that the prescription period for these claims is 3 years from the first day following the year in which claimant learned about the facts underlying the claims or ignored such facts with gross negligence. Irrespective of both, the claim prescribes within 10 years as of the year following the year in which the claim came into existence. We come to the conclusions. First conclusion, unless all co-owners are economically under factual control of a single entity, any form of co-ownership deprives each co-owner from fully benefiting from the advantages of the IP or being in full control of it, but this cannot always be avoided. Part ownership leaves each part owner more freedom, but even the great grant of simple licenses or possible compensation claims for excessive use may become an issue. Compensation claims for excessive use by part owners are decided on a fact-driven basis on equitable grounds, and this makes them less predictable than other legal claims. Due to the freedom to contract, parties can and should avoid these pitfalls by entering into contractual agreements which regulate all foreseeable points of potential dispute between the parties. This includes, and I think I just showed this briefly to you. I think it's obvious from what we have discussed. It's all the before points and they should be covered. What I would like to say is, of course, if you in your patent department or in your company as legal officer have to deal with this situation, you can use templates which you have used previously in your company, or which you get from the internet, or which you get from a book. In that regard, I only have one warning. Always think that these templates were derived from agreements that were made for a certain case, so from a certain perspective. If you are in a strong position, it might not be good to take a draft agreement that was provided by a party that was in a weak way negotiation position. You have to think always whether the template you use really reflects the situation that corresponds to your situation and your interests. And since this is not explained in these templates, this is not always simple, but you have to do this exercise, because if you simply take the template, you may end up with good legal wording that is, if you read it, perfect, but that doesn't suit your specific case and needs. And with this, I conclude and wait for questions. Thank you for your patience.
Yes. Thank you, Eric, for this excellent presentation. Yeah, are there still questions from the audience? If so, please enter them into the Q&A function. Yeah, I've already said it in the beginning. The slide deck that Eric presented, and also a recording of this webinar, a link to that will be sent to you in a follow-up email that will go out probably tomorrow. Yes, I see that there are no open question now.
I have a question.
We have run a bit late, and I apologize for that. But we can certainly continue our discussion next week in part 2 of this webinar series, right, with Professor Hedeke, who will deal specifically with priority claims and problems arising from co-ownership situations, specifically at the EPO. Yes, and sorry, we actually got one question from Lydia. Thank you very much for putting in that question. And the question is, what happens in case of insolvency of one party? So if one party goes insolvent.
In which setting?
The co-ownership.
Joint ownership or the common ownership? For the common ownership, as I have mentioned, the insolvency proceedings lead to the dissolution of the partnership. And that means that the partnership is liquidated and the assets are liquidated. And that might be through public auction, for example, also. In the other case, you will have the liquidator or receiver, better receiver, as party representing the assets of that part owner, and you will have to deal with that person.
Okay, but that's also something that you would advise to regulate in a contract.
It's a bit difficult because, you know, insolvency laws are in general mandatory laws, so it's a bit difficult. You know, we have this problem with license agreements, where insolvency situations produce big problems, and it's not easy to deal with this kind of situation. Yeah. Perfect. I have no ready-made answer for this. You have to also, unfortunately, in this case, you have to deal with a specific case. But I have a question to all colleagues who are present behind the camera, where I only see the eye, who know the co-ownership situation in their country. They now have heard how difficult things are in Germany, or how difficult they can become. Can anybody raise a hand who thinks that in his or her country the situation is easier to handle?
I'm just checking. No raised hands here. So either the audience is not so knowledgeable about the foreign situation, or more likely the situation is also complicated in other jurisdictions, I imagine. So I think it's worthwhile, yeah, to do consider these issues and rely on agreements instead of the legal fallback position provided by the law. Yeah, but for this, I think we can close this webinar. So thank you again for your attendance, and we would be very pleased if you could fill out the feedback form, as this also was our first webinar. If you have any feedback or tips for us, that's very welcome. So thank you again for listening in, and looking forward to seeing you next week. Thank you.
Thank you.